Well, good evening. This is Katharina Boele-Wölki speaking, and I heartily welcome you all to our Comparative Family Law Methodology Week, which has been organized under the auspices of the International Academy of Comparative Law. I'm president of this academy, and together with the Deputy Secretary General, Dr. Alexandre Senegachnik, we have organized this second Jus Comparatum topic, the Comparative Family Law Methodology. I think we have all people who are interested to share their views and to listen to the contributions that they are now locked in via Zoom. This is a whole week that we meet each other always at 6 o'clock for 75 minutes, 6 o'clock European time. This is the most convenient time regarding the different time zones. We have three different formats during this week. Today we start with the keynote, and then the next 3 days we will discuss various papers that have been prepared. And on the last day, on Friday, we will have a round table where we will identify main takeaways about what we have learned this week and how does the roadmap for the future possibly look like. We have published a call for papers and received many submissions. Out of these submissions, we selected 10 abstracts. And we asked the authors of these abstracts, some of them are co-authored, so are written by two, asked them to draft their paper. This paper has been sent to discussants with specific expertise. And we have three different topics. We classified these papers. The first one on tomorrow is on comparative family law methodology and interdisciplinarity. The next one on Wednesday will focus on what is happening in Africa. And then the last one, there we will have 4 different papers to discuss. They are on state, society, and religion. It was not so easy to classify them clearly, but I think we made a good start. We have asked for each session, Tuesday, Wednesday, and Thursday, 2 discussants, and they are also present here today and will join us hopefully during the week. We are looking forward to their feedback. Since the papers as such will not be presented, we have not time for that, but all the papers are on the website, and those who would like to contribute and ask questions are asked to read all the papers in advance, or the specific paper. If you would like to know where to find them, they have just been put into the chat by Alexandre, where the website where you can find all the papers. Well, I'm looking forward to good discussions and good feedback on the papers. And finally, they will be electronically published, these papers all together, also on the website of the International Academy of Comparative Law. Well, we have for each session only 75 minutes, and today we start with the keynote. And before I say a few words about our keynote speaker, I ask Alexandre whether he wants to add something from an organizational or technical point of view.
Thank you. So hello, everyone. I'm just behind the blue screen. I will keep it very short because as Katarina has said, the idea is really to maximize our time and to have a fruitful discussion. You have everything you need on the website that is just behind me. You will be able to see the articles as mentioned and also some capsules. So some of our authors have agreed to present in 180 seconds their papers, and that is really for you in the audience so that you have the possibility to really prepare in advance these papers. There will be more added during the night, and we will look forward to a wonderful start of the paper discussions tomorrow, but that is only tomorrow. So I give the floor back to you, Katarina, so that we can have the wonderful inaugural lecture now. Thank you very much.
Thank you, Alexandre, and it is my great pleasure to introduce to you Rhona Schuz, who is a full professor of law and director of the Center for the Rights of the Child and the Family at the College of Law and Science in Israel, and she's also a professor at the Faculty of Law at Bar-Ilan University. She has stayed for many years in the United Kingdom. There she obtained an MA in law and at the University of Cambridge, and she obtained a PhD from the University of London. Rhona has written extensively in the areas of family law and private international law, and she is a very, very well-known author in the field of child law, international child law, in particular child abduction law, and she published a book in 2013 on this topic, and this book has been widely cited in the worldwide literature. It is the standard work in this field, and not only cited by legal scholars, but also by courts, the Supreme Courts of the UK, the USA, Canada, and in Israel. So nobody can deal with this topic without taking publications of Rhona Schuz into account. And we are very grateful that you accepted our invitation to well, inform us, share with us your views on international child law. And you have also prepared a PowerPoint, and we are looking forward to your presentation. And afterwards, there will be also the opportunity to ask you some questions. Please, Rhona, the floor is yours.
Thank you very much, Katarina, for those kind words. Good evening to everybody. It's a pleasure to be here at this important event. And I hope I'll be able to participate in some of the discussions over the next few days as well. The purpose of my lecture today, and maybe I'll now put my PowerPoint up, so that's okay. The purpose of my lecture today is to discuss and highlight the importance of comparative law in connection with the work of the Hague Conference on Private International Law, both in the preparation of conventions and in the field of family law, and in monitoring the implementation of those conventions. The comparative law work of the Hague Conference is, it seems to me, of particular interest for a variety of reasons. One of them because of the sheer number and variety of states involved. I want to start off with a short introduction about the Hague Conference. The Hague Conference was founded in 1893 as a platform for developing unified private international law rules. The initiative to set up the conference was that of Tobias A.M.C. Asser, an expert in private international law, with a vision to promote peaceful settlement of international disputes. In 1911, he received the Nobel Peace Prize, above all for his devoted work at the Hague Conference. I would remind you that private international law deals with three issues which can arise in cross-border disputes which are connected to more than one state, and that is jurisdiction, in other words, in which state is a dispute to be heard, applicable law, which law will actually apply to determine that dispute or apply to the issue involved if we don't actually go to court, and the question of recognition, enforcement of judgments given in foreign states. Today, there are 85 state members of the Hague Conference, 84 states and the EU from all parts of the globe, but non-member states can also accede to conventions. Since its inception, nearly 50 conventions have been negotiated and adopted under the auspices of the Hague Conference. Of these, 17 deal with family law issues, including 3 which from as early as 1902. On the next slide, I've put a list of what I call the modern family law conventions during the last 50 years and the number of state members, state parties to each of those conventions. Now, as you can see, the abduction and inter-country adoption conventions have attracted far more members than any other convention. 2 explanations immediately spring to mind. The first is that both of these conventions address serious international problems which endanger the welfare of children. The second is, as Linda Silverman notes in her 1999 lectures, these conventions contain an additional element over and above the traditional harmonization of private international law rules, and that is cross-border cooperation between state authorities. And that's also actually true of the 1996 Child Protection Convention and the 2007 Child Support Convention. I'm not going to explore the reasons why the earlier conventions attracted so few members, but I would point out that all of the Hague Conventions did actually receive an unanimous acceptance by all of the state members of the Hague Conference. So the text itself does indicate consensus at a certain level, although sometimes there are reservations from particular provisions in relation to which there is a divergence of opinion. Moreover, even where states have not joined the convention, law reform in individual states might have been influenced by some of the solutions, and it might have been a starting point for later harmonization initiatives. For example, the EU matrimonial property regulation of 2016 takes some of the ideas in the original Hague matrimonial property regime convention of 1978 and modifies them. In any event, the pre-convention comparative law research, which covered most of the member states at the time, is of interest in its own right, irrespective of the number of states which eventually joined each convention. Just mention 2 other bodies who are involved in harmonization of private international law in the area of family law on a regional rather than global level. Of course, there's the I put European Community, and so it should be European Union, Brussels 2 bis and Rome 3. And of course, there's the Council regulation of 2016 on matrimonial property regimes. And this is, I think, worth bringing attention to, because inter alia, because of extensive comparative law research which preceded this regulation. This involved preparation of 16 detailed national reports from the EU member states and a detailed comparative study, which I think was a useful research resource for anybody doing research in the area of matrimonial property law. The second body is the Inter-American Specialized Conference on Private International Law, dealing with states from largely South America or Mid-America. And here's three conferences, 3 conventions in the area of family law, which have been adopted by that organization. Okay, just one final point before we actually go on to look at the work of the Hague Conference, the comparative law work associated with the work at the Hague Conference. And that is the question as to why harmonization of private international law has been so much more successful than harmonization of a substantive law generally, but in particularly in the field of family law. I think there's maybe 2 main reasons. One is, if you like, importance or maybe need. Harmonization is the only way to resolve problems which arise in cross-border disputes which of course cannot be resolved solely by internal law of individual states, such as prevention of forum shopping, prevention of limping status of adults or children caused by differences in the law in different states or conflicting judicial decisions. And more recently, the need for cooperation between states in order to combat cross-border phenomena which are liable to be harmful to family members, such of course as international child abduction and international surrogacy arrangements. The second is the question of feasibility. Generally, private international rules are less likely to reflect deep-rooted social and cultural norms than substantive rules, and so it's easier to find common ground. Of course, there may be public policy issues, but these are usually dealt with by narrow public policy exceptions in the various conventions. Another reason is perhaps that cross-border issues affect a smaller number of cases, and so maybe it's easier for states to compromise in relation to substantive family law, which of course affects every single citizen of their states. Okay, so after that introduction, I will go on to talk about the use of comparative law in the work of the Hague Conference. We'll start off with the use of comparative law in the process of drafting the conventions. At the outset of any harmonization project, comparative law is necessary in order to identify the need for a convention and the issues which it's designed to resolve. Comparison is required both in relation to substantive and private international rules in the various states. Substantive rules in order to clarify the extent of and potential implications of conflicts between the law of different states. So, for example, if we're talking about harmonization in the private international rules relating to matrimonial property regimes, it's necessary, first of all, to understand the differences between the matrimonial property regimes in the various states and the actual impact of those differences, so that we know what is actual potential for a conflict in cross-border cases. And a comparison of private international rules is necessary in order to clarify the differences between the laws of different states which need to be bridged, and whether it's likely to be feasible to achieve a consensus. In addition, pre-convention comparative research can be useful later after the convention has already come into force, and that is in order to shed light on the intention of the drafters, which is necessary when interpreting and applying the convention. And one example of that is two pieces of comparative research which were conducted prior to the adoption of the Abduction Convention, which I'll talk about in a minute, showed that the typical international abduction scenario at that time was where a non-custodial father took the child away from a custodial mother. Thus, it is reasonable to assume that this must have been the situation which the drafters primarily had in mind when drafting the provisions of the convention. This insight is highly relevant when considering how to interpret these provisions to cases where the abductor is the custodial mother, which is actually the typical scenario today. Now, a number of different research methods can be identified which were used by the Hague Conference in its preparatory work. Firstly, traditional literature-based research by the Hague Conference staff of the Permanent Bureau at the Hague Conference. For example, reports by Adair Dwyer, who was the Deputy Secretary General for a number of years, prior to a number of the projects, abduction, marriage and child protection. There's also the Van Loon report in relation to inter-country adoption. This report is extremely informative because it provides comparative law in relation to domestic adoption provisions and international private international rules of adoption, as well as inter-country adoption. So it's a particularly informative document. The second method is questionnaires addressed to governments, which was used in most projects. typically these questionnaires ask two types of questions. First, in relation to national, substantive and private international law. We can see that, for example, in the questionnaires addressed to governments in the relation to the Abduction and Matrimonial Property Conventions. And the second is questions asking the opinions of the states involved about the various options for harmonization and whether they will be prepared to accept particular solutions which were already being thought about at that time. And of course, that's necessary in order to know whether a particular option is likely to be feasible. If none of the states support it, then there isn't any point in actually continuing to consider it. These responses to the governments are usually published when the convention is eventually passed in the volumes of acts and documents. But in most cases, there isn't actually any comparative analysis of the response. Of course, it may have been done in-house and not published, but I think that's a bit of a pity that there isn't actually published any comparative analysis of the various responses. The third method is questionnaires addressed to other stakeholders, and here are a couple of examples. Prior to the Abduction Convention, then there was a study carried out by the International Social Services on the basis of questionnaires completed by ISS's branches in a number of countries on the basis of abduction cases with which they had actually dealt with in practice. And there are also a number of questionnaires in relation to the Parentage project, which I'm going to go into in more detail in just a minute. Now, of course, the use of these questionnaires represents an attempt to look beyond the law in the books to the law in action, a topic which I noted is discussed in one of the papers, which we'll hear about later during the week. Now, I want to elaborate a little bit about the Parentage Surrogacy project, which is still being studied. It's a project, it's an ongoing project. And I think it is a good example of the use of comparative research in preparation of a convention. Of course, we don't actually know whether there will be a convention. Let's hope there will. But in any event, the comparative research here, I think, is of great interest. The background to this project, or the original motivation behind the project, is the urgent need to regulate international surrogacy arrangements, which are often referred to short as ISAs, largely because of the potential for the violation of fundamental human rights of the child and the surrogate mother. These risks have come to the fore as a result of publicity given to some cases in which children were left stateless or without parents, and the problematic practices of some clinics in that time in India, documented, for example, in the film Google Baby. I'm sure most of you are familiar with these issues. However, the project is actually much wider and aims to provide solutions to problems caused by the substantial variations between the laws of different states in relation to the wider question of which adults are considered as the legal parents of a child, generally, not only in cases of surrogacy. In an area of globalization and increased international mobility, these variations can result in limping status. In other words, the parents who are raising the child may be recognized as his legal parents in country A, but not in country B, or at least one of them may not be recognized in the other country. Now, a bit about the comparative research carried out within the framework of this project. In 2012, a preliminary literature-based study was published about international surrogacy arrangements, outlining different approaches to both domestic and international surrogacy. The next stage was to collect more detailed information about the legal position in each state and the factual situation on the ground by distributing 4 different questionnaires to various stakeholders in the member states. The first questionnaire was a traditional questionnaire submitted to address the governments, although it was particularly comprehensive. It includes 92 questions about national, substantive and private international law in relation to the determination of parentage, covering a wide range of matters such as registration, how parentage is contested, or when it can be contested, as well, of course, to the approach to parentage in cases of ART, artificial reproduction techniques. The second questionnaire was addressed to legal practitioners who practice largely in the field of international surrogacy arrangements, and their questions related mainly to their experience of advising parties in these. And this included lawyers in incoming states and outgoing states, in other words, in states where the surrogacy actually took place, the birth of the child took place, and in cases of the states where the intended parents came from, and of course to where they wanted to return with the child following the child's birth. The third questionnaire was addressed to health professionals who had experience in cases of international surrogacy arrangements, and in particular concentrated on their views about the minimum safeguards necessary in any global regulation of ISAs. The fourth was to surrogacy agencies, who of course were asked about their experiences and the various problems which they had involved in international surrogacy agencies arrangements. In addition, the Hague Conference received 31 submissions from intended parents about their experiences. Now, unfortunately, the responses to all these questionnaires have not yet been published. I hope one day they will. But in the meantime, there is a detailed summary of these responses prepared by the Permanent Bureau, which categorizes the various approaches and gives concrete examples which were documented in the questionnaires. Anyone doing research on this topic should read this. Now, just a few words about the continuation of this project. In 2015, on the basis of the information obtained in these questionnaires, the decision was made to continue working on the project by setting up a working group comprising over 20 experts from different geographically representative countries. There have been 8 meetings of this group, but there is still no final recommendation as to the outcome of this project, if anything is going to come of it, what exactly is going to come of it. The group is expected to report to the Committee of General Affairs and Policy at the Hague Conference, which makes decisions about the work of the conference in March 2023. So there's still some time before. Now, the diversity and different approaches revealed by the questionnaires have informed the work of the experts group. So here we really see actually how the comparative research has been critical in the course of discussions about where this project is going. And it maybe explains the cautious approach that has been taken in relation to the feasibility of the project. In other words, the diversity and differing approaches makes those involved rather cautious as to the extent to which it's going to be possible to achieve a consensus and to actually formulate a convention which can be adopted. Now, whilst the group reports of the group indicate that it should be possible to achieve consensus for a convention on the recognition of judicial decisions in relation to parentage, and perhaps even applicable law in cases of natural birth, it's far from clear that it's going to be possible to negotiate some form of a document. They're talking about an optional protocol in cases of ISAs, which would command sufficient support. In particular, any such convention, it seems, or protocol would have to include safeguards in the state of birth. Otherwise, receiving states would not be prepared to recognize the status of the children according to the law of the state of birth. The problem is it's far from clear how it would be possible to ensure compliance with such safeguards. We could perhaps state them. How could we actually ensure compliance with them? The political volatility of the whole topic is perhaps illustrated by the fact that in every document which I have seen, I looked at all the documents on the website concerning the project published by the Permanent Bureau, there is an express disclaimer the project does not indicate that the Permanent Bureau is in favour of surrogacy or opposed to it. I think it's also worth highlighting the fact that whilst the comparative research was of critical importance at the outset of the project, its long-term value is rather diminished by the changing dynamics of ISAs. For example, since that research was done, there have been considerable changes in the situation and in the overall picture. Some developing states, such as India, for example, no longer allow surrogacy by foreign residents. And some of the anti-surrogacy, primarily European states, are now giving some degree of recognition to parental status, largely on human rights grounds. I see that again, one of the papers to be discussed later in the week discusses the developments in Italy in this respect. Now, the Permanent Bureau did actually provide an update in 2015. They were obviously aware of these new developments. They did provide an update in 2015, which is the preliminary document 3A of 2015, which referred specifically to comments by the United Nations Children's Rights Committee about surrogacy arrangements, and of course the jurisdiction of the European Court of Human Rights in the important case of Menacin against France. However, of course, even that case has to be read in the light of later jurisprudence. And I note that there was a case this year concerning Ireland, which some at least consider has limited the impact of the Menacin case. Obviously, now here isn't the place to go into detail about those developments, but I think it illustrates an important point about how any comparative research can very easily become out of date because of later developments. Okay, now I want to go on to the second part of my lecture, and that is to talk about the role of comparative law in monitoring implementation of the Hague Conventions. Now, in order to assess the degree of uniformity in implementation, it's of course necessary to compare the way in which the convention is implemented in different states. Now, before examining the methods which have been used by the Hague Conference to monitor the implementation of the convention, I want to say a few words about the importance of uniformity and also about the reasons why there are likely to be not inconsiderable disparities in the way which conventions are implemented if active steps are not taken to promote uniformity. Okay, and this will of course enable us to understand the importance of comparative law in the post-convention work at The Hague. And I will then also discuss the methods of promoting uniformity. After we've discovered what lack of uniformity there is, what can we actually do to try and overcome the problems and promote uniformity? And lastly, the methods which have been used at The Hague to monitor the implementation, in other words, what comparative research methods have been used by them. Okay, sorry, I didn't proceed with the slide. Okay, basically the slide just tells you what I'm going to talk about for the remaining part of the lecture. So I will now talk about the importance of uniformity. I think maybe these points are fairly obvious, but I think they're worth stating why it's very important that we have uniform implementation of these harmonization conventions in the area in general, but in the area we're talking about of family law and private international law. We need uniformity in order to realize the objects of each convention and harmonization. Significant lack of uniformity indicates the conventions are not being interpreted and applied in accordance with their underlying objectives. If contracting states interpret and apply the conventions differently, then the whole objective of harmonization is likely to be undermined. There will still be an incentive to forum shop, and adults and children may still suffer from limping status. And there is a risk of inconsistent and conflicting decisions in different states. A classic example of this is the United States case a number of years ago now of Johnson against Johnson, in which a Swedish court refused to return a child to the US because it took the view that the child was now habitually resident in Sweden. But the US court ordered return of the child to the US on the basis that, in its view, the child was still habitually resident in the US because there was an agreement to that effect between the parties. So here we can see that inconsistent or lack of uniform implementation actually means we end up with inconsistent judicial decisions, and we haven't resolved one of the problems which we aim to resolve when we created the Harmonization Convention. Of course, lack of uniformity is likely to reduce, I'm sorry, I've written this wrong, it's likely to reduce certainty and predictability. That was a mistake, I can change it, I apologize. And it's also liable to reduce equality, lead to greater inequality among people affected by the convention in different states. Now, why are there likely to be disparities in the implementation of conventions if we don't take steps to promote uniformity? There are a number of causes. Firstly, it's inevitable there will be lacuna and ambiguities in international conventions. Sometimes this is because of lack of foresight, other times things have been left vague, but this is the only way to achieve consensus. Now, in national legislation, when ambiguities are discovered, then it's usually possible to amend the legislation. In the case of international conventions, it is virtually impossible to obtain consensus from enough member states to make amendments possible. And this is why plans for a protocol, which was designed to resolve some problems in the wording of the Abduction Convention, had to be scrapped in the end, because it was realized that there simply would not be sufficient consensus among member states for such a protocol. Second reason is differences in national law. Sometimes variations can be found in implementing legislation in those states where international treaties are not self-executing. For example, in relation to the Abduction Convention, the US legislation provides for a higher burden of proof in relation to some of the exceptions to mandatory return in the Abduction Convention. I'm not aware of any other state which has adopted that approach. Maybe more generally, or more importantly, differences in the structure, characteristics, traditions of different legal systems may lead to significant disparity in implementing the convention. For example, the same term may have different meanings in different states. In relation to the Abduction Convention, this problem has arisen, for example, in relation to the term habitual residence and rights of custody. Similarly, mechanisms which might be adopted to fill lacunae in the convention might not be available in all systems. For example, in abduction convention cases, common law systems have adopted a practice of requiring left behind parents to give undertakings to ensure that the abductor can return with the child without the child being exposed to a grave risk of harm. For example, to provide separate accommodation for the child and the returning parent, or not to bring criminal proceedings against the returning parent. However, the concept of undertakings is not known in many civil systems. Another inherent difference, which is a serious obstacle to uniformity, is the fact that in some legal systems, foreign decisions are not relied on, even when interpreting international conventions. A third difference relates to political will. A third reason for disparity relates to political will and resources. Effective implementation of those conventions whose operation requires the involvement of the authorities of the contracting states is dependent on the provision of adequate manpower and resources to those authorities. This has been particularly evident in relation to the abduction and the inter-country adoption convention. A fourth reason is the impact of other instruments, whether they be regional or global. the interrelationship between Hague Conventions and other instruments may cause disparity between the way in which a convention is interpreted and applied by those states which are party to such other instruments and those which are not. And the classic example here is perhaps the European Court of Human Rights, a decision in the quite well-known case of Neuliger against Switzerland, which emphasized the need to consider the child's best interests in deciding Hague abduction cases, which approach appears to be at odds with the Convention's automatic return mechanism as understood by the vast majority of member states. Fortunately, the Grand Chamber, in its later decision in X and Latvia, backtracked to some extent, clarifying that the best interests of the child have to be evaluated in the light of the exceptions in the Convention, in the framework of the exceptions. Although the lack of clarity is still likely to prejudice uniformity, even among those states who are parties to the European Convention on Human Rights. An additional reason for disparity in implementation is ideology and culture. National differences in ideology and culture. A good example of this can be seen in Katarina Trimming's study of the way in which return applications were handled within the European Union and Brussels 2 bis. Her empirical analysis reveals significant differences between the new states, Central and Eastern European countries which had joined the European in 2004, and the old states, both in relation to outcomes and the time taken to process the applications. Her follow-up research, which included interviewing representatives of the two central authorities in the new states, and literature researchers produced two main explanations for this divergence. One of these relates to the fundamental historical differences, stemming largely from the communist history of the new states and a lack of trust towards their former, as she put it, enemies. As her research suggests that the old communist era judges would find it difficult to return a child to a capitalist requesting state, particularly where the abductor was a local national. Now, differences in national ideology and culture are, of course, likely to become increasingly relevant as more and more non-Western states accede to conventions, which has happened over the last few years, and of course, in principle, is a very welcome development. Now, differences in relation to conventions which are applied by individual judges, differences in application may also be due to personal ideology of the judge. For example, in case law on the abduction convention, it is possible to discern differing worldviews in relation to domestic violence and in relation to the place of children in society and to their rights and their capacity. Okay, now I want to go on to discuss very briefly methods to promote uniformity. So once we've discovered by comparative law that there is lack of uniformity, what can we actually do to try and promote uniformity? Now, there are a number of methods. First of all, recommendations can be formulated as to which is the better way of interpreting the convention and applying it. And we see this in the conclusions and recommendations of the various special commissions which take place in relation to some of the conventions at The Hague, primarily the abduction, the child protection, and the adoption convention. These special commissions take place approximately every 5 years and attended by delegates from the various countries. And at the meetings, they discuss various problems which have come to light in the operation of the conventions. And at the end, there are drawn up conclusions and recommendations. And these are used actually, they're sometimes referred to even by courts. They're certainly taken into account by, at least in some countries, by the central authorities and those who operate the convention. So they certainly can promote uniformity. Similarly, the Permanent Bureau has developed good practice guides in relation to a number of aspects of the Abduction Convention. And the background to these was the comparative law research, which we'll talk about in a few minutes. A second method of promoting uniformity is by the dissemination of reported decisions and relevant research. And there are examples in the case law where this has influenced judicial decision-making. For example, in the United States Supreme Court, on a couple of occasions, it's had to resolve circuit splits as to how the convention should be interpreted in relation to rights of veto, in relation to the meaning of habitual residence. And in deciding which of the two approaches to accept, the Supreme Court has been highly influenced by comparative research, by reported decisions and comparative research from other countries, preferring the approach which has been adopted by most other contracting states. Third method is judicial and administrative liaison and training. This is, of course, particularly important in states where there are implementation problems, but of course that is one of the purposes of comparative research, to discover which states have implementation problems. Okay, finally, although there's only really one example of it, it's just mentioned it, and that in principle there's a possibility of sanctions for non-compliance. The US does do this in a certain way by having a sort of a blacklist of reports of states which are not compliant based on its annual State Department report, incidentally not only in relation to the Abduction Convention, but in relation to other human rights conventions. Okay, now to look at the various comparative tools which have been used by the Hague Conference in its post-convention work. Of course, the traditional case law-based research, comparing judicial decisions, and this has provided important insights into the application of the Abduction Convention. One example would be a paper prepared by the Permanent Bureau in 2011, looking at the ways in which domestic violence was or wasn't being taken into account in applying the Article 13b grave risk exception, which analysed case law from a considerable number of jurisdictions. Second method, and this of course is extremely important, is by having a case law database. And in relation to the Abduction Convention, the Permanent Bureau has set up Inaugural, which contains summaries of decisions in different contracting states. And where available, there is now a link to a full text. Of course, not always in English, but sometimes it is a translation. The database includes a variety of search engines, including keywords, articles in the convention, or states involved. There is some case law analysis in relation to some specific issues. This has been prepared by leading academics in the field. Now, this database is extremely important because it substantially increases the access to judicial decisions in Abduction Convention cases and broadens the range of decisions which can be compared and analysed by scholars. I found it absolutely invaluable in writing my book. And of course, it can be used by the Permanent Bureau itself. In the domestic violence reflection paper, there was considerable reference to decisions which were discussed, which appeared on Inaugural, to summaries which were published on Inaugural. I'm pleased to say that in recent years, there's been an increase in the number and range of states represented on Inaugural, where there are summaries of the decisions, and we can see decisions from states, Asian states such as China and Japan, and also South American states. On the other hand, I noted that the number of cases per year seems to have decreased, which is perhaps rather surprising, and there's no evidence in the reduction in the number of cases in practice. A third tool is statistics. Now, there have been statistical surveys on the operation of the Abduction Convention, 4 in all, under the expert direction of Professor Untitled Chapter, and these have been prepared and published. and they're based on data provided by the central authorities in each of the contracting states in relation to both incoming and outgoing abduction convention cases. They include information in relation to the profiles of the parties and their children, as well as the outcomes and ground for refusal to return. These surveys are absolutely invaluable in understanding how the convention works. And in particular, for example, the surveys have consistently shown that over 70% of abductors are mothers, and that over 80% of abductors are primary carers or joint primary carers. Whereas, as I mentioned earlier on, the assumption on which the convention was drafted seems to have been that the typical scenario is that of abduction by a non-custodial father. Now, that certainly is not the case today. There's also been statistics in relation to inter-country adoptions. There's analysis by Peter Selman of data obtained from receiving and sending states between 2004 to 2019, showing the trends, which of course is very interesting. All of these statistics are of course available on the website of the conference. An additional tool is country profiles. Governments fill in forms explaining the relevant law and procedure in their state. This provides assistance for professionals and lay persons affected by the conventions worldwide. Country profiles have been used in relation to the Abduction Convention and the Adoption Convention. There also seem to be country profiles under the 2007 Recovery of Child Support Convention. As far as I can see, they're not published and seem to only be available to the member states themselves. An additional tool is questionnaires to governments. Now, of course, we're talking about post-convention questionnaires. Governments are asked to fill in questions, complete questions about the operation of the conventions. We see this mainly in relation to the Abduction Convention and the Child Protection Convention, and also the Adoption Convention. And they're usually sent, these questionnaires are usually sent to states prior to the special commission meetings, which I talked about earlier. The responses to these questionnaires, which are published on the Hague Conference website, contain a vast amount of fascinating information about the operation of the convention in different states. They generally include reference to decided cases, practice, and specific problems encountered, but also some rather wider. For example, I noticed in the questionnaires on adoption, then the states were asked to give details about the degree of access which the adopted children had to their origins. And we're talking about children who've been adopted from another country. And that was, I found that very interesting to find the differences between the different receiving states as to the possibility of the children obtaining information about their origin. Unfortunately, not all states fill in the questionnaires, although sometimes that might be that there is a paucity of cases and therefore they think it's worthwhile. Sometimes there's specific questionnaires about a particular topic. For example, there were questionnaires about the problem of enforcing return orders made under the Abduction Convention. The responses to these questionnaires were actually summarized in a comparative legal study on enforcement of orders made under the Abduction Convention, which was published in 2006. And that study formed the basis of the later guide to good practice on the subject of enforcement of return orders. Finally, I will just also mention the Judge's newsletter, which is published online by the Hague Conference and contains articles about the operation of the various conventions in different states. Sometimes the articles are about one state, and sometimes they're in the form of national reports. Just a few concluding comments. Just very briefly, some comments about methodological issues. Whilst I have no doubt that the comparative law research has been invaluable to the work of the Hague Conference for many years, both in preparing conventions and more recently in monitoring their implementation. It does seem to me that some of their work does raise some methodological issues which are worth mentioning very briefly. Firstly, sources of the materials. Much of the material is provided by governments and member states. This has certain advantages. Governments may have information, for example, statistics, that's not available to individual researchers. On the other hand, there may be disadvantages, particularly in relation to preparatory work, because the government employed lawyers who, for example, prepare responses to the questionnaires, may not necessarily be experts in the relevant field, and may not necessarily have the depth of understanding which would be more helpful. Huge problem is keeping up to date. The dynamism of many areas of family law in the last few decades means that comparative law studies may become outdated very quickly. We already mentioned this in relation to the Parentage project. It's also important in relation to post-convention work. It's very important that the country profiles are kept up to date, which unfortunately doesn't always happen. In relation to case law analysis on INCADAT, again, not all the analyses are kept up to date. I'm sure there are resource implications and reasons for that. That is a pity that many analyses don't include recent cases. Third point, which is maybe of more general relevance, the use of raw material as opposed to comparative analysis. Some of the Hague Convention's comparative research is basically provision of raw materials, such as responses to questionnaires, country profiles, or case summaries, but it doesn't always go on to actually carry out analysis of those raw materials, or at least it doesn't publish that analysis. So that's one point. A second point is, I think that when looking at the questionnaires, the preparatory questionnaires, sometimes more useful comparison might be facilitated by a wider use of case studies. For example, asking the respondents to explain how a particular situation would be addressed by the law in their state, rather than simply setting out the law. There are a few cases where they did use case studies. For example, in the preparatory work on the matrimonial property regime. Unfortunately, it doesn't seem to have helped in bringing a large number of states to join the convention. But it is an example of use of case studies, but I think that should perhaps be more widely. Thirdly, in the INCADAT case law analysis, it's pretty basic. It usually gives a list of which cases support a certain approach and which cases support another approach. And there isn't any deeper or more nuanced analysis or significance or discussion of the significance of the different approaches. Now, this might be largely because of limited resources. There isn't anybody available to do that. Or it also may be partly political, because the Hague Conference is very careful to stay neutral and not to avoid preferring the case law of one country over that of another. Now, of course, all of these gaps here could be filled by researchers like you and me. So that raw material, it can be an excellent source of research, and the additional layer of the comparative analysis can be added by private academic research. Summary. Comparative law is essential for any harmonization of law. The Hague Conference has developed tools for obtaining raw materials to facilitate comparative law analysis, both in preparing and monitoring conventions. These materials have clearly informed the work of the convention, although the conclusions which can be drawn from those raw materials have not always been published. I mean, sometimes there has, but sometimes not. In any event, there is a wealth of material available to academic research. The fact that so many states are members to the Hague Conference, and an even larger number of states have joined some of the convention, provides a huge potential for broader comparative law than was available in most traditional comparative law studies. Perhaps wider collaboration between the Hague Conference and academic researchers on particular projects would enable this potential to be more fully realized. I hope that you have found the lecture informative and interesting, and I will be happy to answer questions. Thank you for listening.
Wonderful, wonderful, Rhona, Schuz. Thank you very much for this very inspiring lecture. The role of comparative law plays in the work of the Hague Conference on Private International Law. So you focused on two stages. First, the preparation of a convention, and then the application, the operation of the conventional rule in each contracting state. How this is done, how this is monitored. I think you provided tremendous input for our methodological week in comparative family law research. And I think you clearly demonstrated also that the Hague Conference on Private International Law provides a wealth of comparative material to study. And as you rightly pointed out, legal scholars are, well, they are in demand to, to support, to submit, to contribute to the work of the Hague Conference, and also to critically analyze all the material and all the steps that are taken. So thank you very, very much. And I hope very much also that you will publish your presentation together with the other papers that we will put on the website of the International Academy of Comparative Law. It is a wonderful entry into the topic. I knew that this would be a success when I asked you, so thank you very, very much. Now we have 13 minutes left, and we have some questions also in our frequently asked or F&A. And now I'm a little confused. Alexander, would you like?
Yes, I can jump in on that. So
yes, please.
We have a few questions, and as we have a bit of time, and so that it is nicer, what we suggest now is, exceptionally for today, we're going to promote those asking the questions quickly as panelists so that they can directly ask you the question in person. That's always nicer, and as you know, instead of just reading it out. But obviously, please keep in mind that we have a bit more than like 13 minutes left. So I will start directly, and we have a question from Professor Antonello Miranda, who is now going to be promoted as panelist and should appear here, yes. And so he should have the possibility to jump in. And we have also one of our authors, Ivan Mugabe, who is going to be promoted as well. So I suggest perhaps Professor Miranda, if you want to start. Antonello?
I'm here. Hello, Alexander. Hello, Catherine.
Hello.
Nice to meet you again.
Nice.
I have two questions, but because I have adapted in a few words, so we are going quickly to on. I think that the comparative law is a science. And if it is not correct to compare different pieces of statutes and try to create a sort of a legislation, upper legislation over the other people. And if this is correct, if the comparative law is a science, I don't think that she have to the comparative law any kind of scope or finality, and the only finality is the knowledge, and we have to compare different systems. That not means that we have to compare the statute law, but the law, and there's a big difference, especially in family law. This is my point of view, of course. Thank you.
Wonderful. Rhona, would you like to answer this question or react to this statement?
Okay, maybe I just made the comment that I think that what you're saying I can understand more in relation to substantive family law. But I think when we're talking about private international law, which basically tells us where family law disputes are going to be resolved, or which law is going to apply to them, I don't think that holds so well. I think in relation to that, then we do need to compare, otherwise the situation is just going to get worse. We want to avoid the problems caused by different laws, and the best way to do that is to come up with common solutions to harmonise the private international law.
Thank you.
And now we have Ivan Mugabe.
Yes, who is, I think now, yes, is a panelist. Ivan, if you would like to ask your question. And I see we also have another question from Elizabeth Perry, which I will then also promote for final
Yes.
Thank you very much. A very wonderful presentation and very insightful. My question is in relation to the method you used to identify the different working groups as a methodological framework. I'm just a little bit fascinated with how you made the choices. Thank you.
Basically, I just gave examples. I gave examples of the work of the Hague Convention or Hague Conference. All of the most recent work over the last few years is available on their website. Some of the earlier work, you actually have to go and get the thick volumes of the acts and documents where they actually record all the different materials. I don't think that there was any methodological method in the way in which I chose. I simply looked for categories of types of tools they use and then gave examples of those types of tools.
Thank you. Then it's the floor to Elizabeth from Sweden.
Well, thank you. I specialize in comparative law because I am originally from the United States and moved to Sweden 10 years ago. So one reason, but and comparative family law specifically. My question is in the chat, and I wonder, I do have access to it here, so I'll just read. But my question was basically about the law in practice in this area, because we teach a class at Stockholm University called Family Law Across Borders, where we had a practitioner from Stockholm come in and talk about the actual access to justice for clients. So I'm wondering if that level of sort of law in action or socio-legal approach is something that plays in with the work that you've been doing, because it does seem to really matter.
Which is becoming much more prominent. The whole idea of access to justice for children is something which I know the United Nations Convention on Children's Rights is the committee is dealing with that topic. I mean, issues do arise. For example, the whole question of children's participation. We have cases under the Abduction Convention. To what extent does the court actually listen to the child and hear what the child thinks about it? So this is a whole area, and this is one of the topics which we can analyze by the various comparative methods, by looking at the cases on Incadat. One of the questions in the statistical surveys relates to age of children. That those are the methods we can find more information about these sorts of issues.
Okay, and just to specify though, the gender aspect of the parental access to justice in terms of who gets the opportunity to be represented by counsel. So the child rights issue is absolutely important, but I wondered if the father, mother, custodial, non-custodial situation, I mean, how you could go further in depth with the comparative methods to that question.
Right, I think that would involve, and I can't remember whether it was an issue which was considered in any of the research. I don't remember seeing it. As to the approach of different states, because the Abduction Convention does allow reservations to be made from the provision about legal aid. So the availability of legal aid to parties in a abduction dispute varies from state to state. For example, in the UK, everybody automatically gets legal aid if they've got an Abduction Convention case, as far as I'm aware. both parties, but I know in other states it isn't like that, and it very much depends on whether there's pro bono representation available. Of course, giving parties who don't have sufficient resources. But that would be a very interesting topic to consider, and it might be something that could be added to one of the country's questionnaires if it's not there already. I think legal aid is possible in one of the questionnaires, but that will be where you would have a look and see in the country's questionnaires whether one of the questions that are asked is about the availability of legal aid and how often legal aid is given.
Right. Okay.
You could ask a different question of whether, to what extent it's given to men or women. Although it's probably a question of the abductor or not the abductor, rather than.
Yeah, and I was thinking a broader access to justice question in terms of who ends up finding competent counsel in time to comply with the convention's requirements, and that sort of home court advantage that the person who maybe has abducted a child to their own home country has in finding appropriate counsel and so forth. So it's a broad and fascinating area. Thank you so much for your talk.
Just to add a point about that, and of course, this really gives the example of the importance of the later conventions, which don't just harmonize the law, but actually set up a cooperation method. Now, the central authorities work on the abduction convention, and so at least in theory, the foreign left behind parent should be able to be given assistance as to how to find appropriate counsel by the central authorities. And that was one of the problems which existed before we ever had that convention. That should be much better today. How it works in practice maybe requires more research, but the framework is there.
Are there any other questions? If not, I would like to ask a terminological question. You have used the term harmonization for the conventions that are applicable in all the contracting states. And to my mind, I think these conventions lead to the same rules to be applied in these contracting states. And I think there should be a difference between unification on the one side and harmonization. Unification means the same rules are applied, like the European regulations. They are applicable in all the member states except a few, but and conventional rules are also applied in the contracting states. We have seen that the application of these conventional rules lead also not only to similarities, but also to differences. But this is another question. But the aim of the convention or a regulation is unification. Do you have a specific reason why not using this term?
No, I must admit, from my perspective, and here maybe this is something I should consider. I hadn't distinguished between the two terms. I didn't specifically consider harmonization as being different to unification. As I was looking at the end result, and the end result is that we have the same private international rules which are being applied by all the member states. This is maybe a nuance which it would be appropriate to take on board. And thank you for that comment. And I will consider it, and I may well change the use of the word harmonization to unification in a written version of it.
Okay. Well, it is 1 minute before we should close this first session. Alexandre, are there any announcements to be made?
I think other than, first of all, obviously to thank again the Professor Schuz for this wonderful lecture. So just two announcements. The lecture will be uploaded tonight on the Academy's YouTube account, so that everybody can watch it again if there's any questions, and that's maybe also more for those who will be joining us only tomorrow. And again, the capsules and articles are on the website. So please come prepared. That is obviously the best for you tomorrow if you want to directly jump into the discussion as well. And other than that, again, thank you very much on my side. That's all.
Well, I also would like to join in the thanks to you, Rhona, Schuz, and also to those who asked questions. Tomorrow we will listen to to the feedback of Marie Cresp and Katharina Keesling, and they will give their feedback to papers of Mark Berker, Elena Faletti, Simona Novaretti, and Joël Long. And we are looking forward to tomorrow. And with this, I'm very happy and a wonderful start we had today. And tomorrow we will listen to other discussions. And thank you for today. And see you tomorrow at 6 p.m. European time. Exactly. Bye-bye.
Bye. See you tomorrow.
Thank you. Bye-bye.
Bye-bye.